Let me nonetheless get us started on our last panel. And as you recognize, as you've looked at the program, what we've tried to do is to focus on several issues that are implicit in this whole concept of the war against terrorism. And we've not yet addressed the direct threat to our country, the continuing threat, and how we have tried to and will continue to try to shore up the defense of this country. And that's exactly what this panel is all about. And I think you'll see how it becomes then an integral part of the whole overall theme of our conference. To chair this panel on Homeland Defense is Walter Cox. Judge Cox is a senior judge, former chief judge in the United States Court of Armed Forces, United States Court of Appeals for the Armed Forces, court that I supposedly knew for 25 years. Sorry, Walter. Court of Appeals for the Armed Forces, formerly the Court of Military Appeals with the acronym COMA, which some of us said is probably not appropriate for that court. He is a senior judge on that court and a visiting professor of law at Duke University School of Law. So, Walter, over to you on this last panel.
Let me start, Scott, by congratulating you and Heather and Judge Everett on such a wonderful conference this year. I've attended all the sessions and enjoyed it very, very much. I'd like to say that publicly before we get started. Homeland defense is not a new concept. Those of you who are constitutional scholars will recall that one of the great debates that went on in forming our Constitution was to what extent we would allow a standing army to be in our country at all. And the debate was finally resolved by creating a small, I think 8,000 was the first authorization, a small standing army to guard our frontiers. But the Constitution still requires an appropriations for our army that can only last 2 years. So the question raised yesterday about the use of our military, our active military force in Homeland Defense, is not a new concept and one that's been on the minds of our country throughout its history. This morning driving in, I heard that there are 3 exercises going on this weekend in Oklahoma. One, an airplane is going to spray a city with some type of non-toxic agent, and the medical people and so forth are going to react as if it were the plague, and they're going to treat the people, I understand, with juice and jelly beans. So that should be a very interesting exercise. And then there are 2 other exercises which will take place, which will have mock terrorist attacks. I think one they might do with contaminated water, putting botulism in the water, and another one has to do with some other disease. So this is an ongoing thing that's happening in our country. And so today, Scott, I'd like to take credit for assembling this panel, but Scott Silliman was able to put together a very, very expert panel on Homeland Defense. And I'll introduce you in reverse order. At the end of the table, Ms. Suzanne Spaulding, who currently is a consultant in national security matters. She's also the chairman of the American Bar Association Standing Committee on National Security. But her background includes service as Executive Director of the National Commission on Terrorism, Executive Director of the Commission to Access the Organization of Federal Government to Combat Proliferation of Weapons of Mass Destruction, served as General Counsel, Deputy Staff Director of the Select Committee on Intelligence of the United States Senate, served as Assistant General Counsel to the CIA, and we are delighted that you came down to share your expertise with us. In the middle, Ms. Kim Kotlar. Kim has a very interesting background. She completed a career in the United States Navy where she was a cryptologist expert. She served in some very exciting positions as that. For example, she was Naval Security Group Department Head in Diego Garcia during the Persian Gulf War, where she supervised a 200-member military and civilian team. I think that is very impressive. Her last assignment was at the National Security Agency, where she helped organize the first Information Operations Policy Office. She served as a congressional fellow. And then she left the Navy, retired, I guess, from the Navy, and went into Homeland Security, National Nuclear Security Administration, and so forth. It's very appropriate for the comments here today. And last, certainly not least, is Lee Zeichner. Lee is also from the private sector now. He is the president of Legal Networks, Inc. Legal Networks focuses on the development of information security laws and regulations with an emphasis on liability, risk management, national security, regulatory compliance, and privacy. He's a graduate of Georgetown University Law Center. He's also a graduate of the University of Florida and received a master's degree along the way in East Asian Studies from Stanford University. He worked for a number of years with the ICC, which is not the International Criminal Court that we've been talking about, but is the National Information Coordination Center. And Lee, we're mighty proud to have you with us, and I'll give you the podium at this time. Thank you very much. Please join me in welcoming our panel.
Thank you very much, Judge Cox, Professor Silliman. It's an honor to be here with you today and to have this opportunity to address the audience and perhaps learn a bit. Shortly after the towers fell on 9/11, those of us in industry that were watching and listening to problems outside of the radius of the World Trade Center saw a pattern emerge quite quickly, which were emails, frantic emails, coming from a number of those in the financial services sector asking a single question: would the liquidity window stay open at the Federal Reserve Board? What was interesting about the question wasn't so much the concern that financial service leaders in this country have access to cash, but the fact that there wasn't a process in place to ask that question in a safe and secure environment. Similar questions began to emerge from other sectors of the economy. There were also questions with regard to donations. Home Depot had boots to give to those at the World Trade Center because they had heard that boots were burning very quickly. Regarding the first responders, who do I call? How do I get them in? Pfizer had vaccines to donate, and in fact, a deal was made, and when they got to the scene, no one would let them in because they couldn't confirm who they were. There was no single point of contact. These are the types of problems I'd like to talk about in the next few minutes. And along the way, I'd like to define critical infrastructure and also make an argument. Critical infrastructures, next slide please. Critical infrastructure can be defined as those services that support the national and economic security as well as the public's health and welfare. We focus on services with regard to those critical infrastructures that we as citizens simply cannot live without: financial services, telecommunication services, transportation, healthcare, electrical power, oil and gas. The argument I would make is that under certain circumstances in a homeland defense environment, we must prioritize service delivery over other equally valid policy options. These issues, I would remind you, are absolutely national in scope. We are not referring to a hacker who's trying to get into the power grid or a problem with regard to liquidity. We are talking about problems which will force people to take money out of the bank. We're talking about problems which will cause panic and will cause implosion of public trust and confidence in our institutions, so much so that they might not return to use those services. Next slide, please. With regard to the problem, the question is, how do we enhance homeland security defense with critical infrastructure assurance? We as a nation lack a single integrated risk management policy as well as a legal foundation to support that risk management policy. Put differently, we have no mechanism to weigh competing policy options and choices. To give you an example, assume that a pound of anthrax were to be delivered to a back office processing facility for a well-known financial institution. And assume further that if the checks that are delivered to that processing facility are not cleared within 72 hours, that we all as citizens and folks who keep money in banks will begin to worry about access to our money. Assume further that within 5 days, if that back office processing facility Well, the way the policies work right now is as follows. If I own and operate that back office processing facility, I will call 911. When I do that, the EPA, the CDC, the FBI, state and local law enforcement officers have done a superb job of coordinating so they all show up at the same time. According to policy, however, we must quarantine that facility for law enforcement purposes, for intelligence purposes, for safety purposes. However, what about the metric? We have 4 days to do something about it. Do those first responders know about that? Does the FBI know about that? Have we considered how to quarantine a facility so that we don't keep it quarantined, given the critical infrastructure realities? Those are the types of problems that we're grappling with right now. Right now, many of these policy options appear to be zero-sum choices, and they're all competing for prominence. And finally, there's no clear way to link budget to the policy options, which is really about accountability. With regard to the range of issues that I've just raised, there's a bit of legal history, which is actually quite interesting and quite important. During the initial terrorist attacks in the early 90s and immediately after Oklahoma City, our federal government began to explore whether or not we had an appropriate legal and policy foundation to approach these types of terrorist attacks which impact the private sector as well as our national security posture. The President's Commission on Critical Infrastructure Protection was stood up. For the very first time, we gave private sector representatives full clearance to hear everything that the FBI, the Defense Department, and the intelligence community were being told. They issued a report in 1997 which had approximately 85 recommendations and led to 3 separate presidential decision directives during the Clinton administration. 62, which dealt with chemical, biological, and weapons of mass destruction. 63, which dealt with critical infrastructure. And a little-known one called 67, which dealt with continuity of operations, a policy which is getting a lot of review right now. During Y2K, we took a look at applications of those presidential decision directives, principally in the critical infrastructure area, and posed the following question. If we had a Y2K glitch that impacted our critical infrastructure, what was the legal and policy foundation for responding? In many cases, what we would experience would not be something that first responders might be needed for. For example, if the power grid somehow were impacted by a Y2K glitch, and suddenly the middle part of the United States did not have any power, did not have access to natural gas, did not have access to gasoline, what would be our response? On the one hand, we could send in FEMA. They could house people, they could coordinate feeding of people, and they could coordinate long-term or medium-term restoration of the environment. An alternative policy option would be to figure out what went wrong. To use 9/11 as an example, if any of you were in the Washington, D.C. area, trying to call into New York City, it simply could not be done. We had problems with regard to the telecommunications infrastructure. For those of you who watched the 60-minute tape with regard to our first responders, their communications capability as first responders was anything less than exemplary. What is our policy with regard to restoring communications infrastructure? The question isn't, do we have a process or not? We do have a process. The question here is, how do we choose the competing policy options? Do we restore the first responders, or do we restore the stock exchange? After 1 week, does that policy change? I'd like to spend the next couple of minutes discussing the competing policy options and then coming up with some conclusions. Those competing policy options are as follows. First, secure federal government information systems. Second, manage the consequences of an incident or emergency. Third policy option, prioritize law enforcement, intelligence, and defense needs. Fourth option, regulate security. And then the fifth option, leverage market pressures to enhance reliability and security. Next slide. Next one. Thank you. With regard to the first policy option, around 1996, the Clinton administration, through the Office of Management and Budget, had argued that if we were to successfully secure the critical infrastructure through the federal government, that there would be no need for PDD 63. I would not argue that this was widely argued, but many within the Office of Management and Budget argued that this was the way to go. There was no need for a presidential policy with regard to public-private information sharing and public-private government's control of its own information systems. One issue that I would pose for you is the following question. Do we still approach the National Security Agency and its legal and policy requirements in the same way that we saw them in the mid-1980s when the Computer Security Act was passed? Back then, there was a sense that you could not give all the authority to the folks who owned and operated the main keys. In other words, if you let NSA build the fence around your information system, the only way you could get in was with NSA's approval. I think a lot of the arguments back then were emotional as well as political, and as well as perhaps based in some form of reality. However, in the year 2002, where are we with regard to NSA and its enormous and positive capabilities in the area of protecting U.S. government information systems? The second policy option, next slide please, is that critical infrastructure is really about creating processes for managing the consequences of an emergency. For those of you who watch very closely the response on 9/11, this would be the coordination across the nation, both the federal and state and local level, of the response to either a natural disaster or, in this case, an attack on the World Trade Center. With regard to our legal foundation, the Stafford Act is the most principal authority. The Stafford Act looks at presidential declarations, which can be triggered principally by governors of each state, who then invite this process into the state in order to help with the response. The Defense Production Act of 1950, for those of you who are familiar with that, offers a great deal of support where there are gaps in the Stafford Act. In areas where there are national defense needs, the federal government can use or trigger the Defense Production Act to prioritize the delivery of goods and services, again, for national defense purposes. So we've used the Defense Production Act a number of times in the last several months with regard to our activities in Afghanistan. Some of you may also know that earlier last year, the federal government used the Defense Production Act to mandate one private sector company sell electricity to another private sector company during the California energy crisis. Now, that caused a lot of problems in Congress, but the issue here also went to restoration and critical infrastructure. We had an energy crisis. How do we get private sector companies that have a business model of their own to do something in the name of national security? So I think that in sum, with regard to this particular policy option, we still see gaps. The federal response plan that was developed for Y2K explicitly excluded critical infrastructure problems, as well as state and local government issues relating to utilities that they owned and operated. Therefore, to go back to my Y2K example in Chicago, if we had problems with regard to the power grid, we would have used the federal response plan process steeped in the Stafford Act, and the process would have worked very well. However, issues associated with responding, recovering, and restoring that particular service from private sector would have been a gap in the federal response plan process. Put differently, we have no legislative foundation to address those types of problems. The next policy option is to look at law enforcement and crisis management. Critical infrastructure, if you take a pure law enforcement and crisis response perspective, is about catching the hacker, prosecuting, and or eliminating the threat. Crisis response under Presidential Decision Directive 39 is aligned very closely with consequence management, so that law enforcement and intelligence personnel are coordinating closely with FEMA, an extremely important policy. That particular Presidential Decision Directive was wrapped into our federal response plan, and there is a terrorism incident annex. And if those of you who haven't seen it, I highly recommend you take a look at that policy document. I would argue that the legal and policy framework in this area is well settled. The real question is how to leverage law enforcement intelligence needs for critical infrastructure purposes. I'll give you a real-life example. If I hack into the power grid right now, 9 times out of 10, it's almost completely irrelevant to the owners and the operators of the power grid. Actually, put more precisely, 999 times out of 1,000, because they've worked out ways to respond and restore seamlessly. You won't even know that there was someone who was trying to hack in or break down the power grid. However, for law enforcement, intelligence, and national defense purposes, that would be extremely important information. And so I would pose the question, to what extent have we integrated those very real intelligence, law enforcement, and national defense needs especially in a post-Enron environment, is that critical infrastructure is about focusing on critical infrastructure services, which are provided in large part by industry owners and operators. Our strategy should be to regulate security. It seems pretty straightforward. The problem is, how do you write a security regulation? Right now, people who own and operate the power grid want to stay in business. In fact, the market pressures to stay in business are far more ferocious than any regulation could possibly be. Well, let's assume that they're not as ferocious as I make them out to be. What would that regulation look like? What are the performance metrics? How do you actually write that into a statute and into a regulation? The SEC has grappled for many years with how to write a regulation for security with regard to Ameritrade, an online brokerage. What exactly do they tell the people who own and operate Ameritrade that they must do? They have to report incidents and outages. Well, that doesn't help keep it online. It might in the long run, but that's not what I would consider to be an operational security concern. What we have come up with are process-related security solutions. The board of directors has to have a security plan. Senior managers have to exercise that plan. You have to have a policy with regard to encryption. The problem is, how do you enhance security well beyond these very minimal fiduciary responsibilities? Most of my practice is in the area of corporate governance, and I can tell you, as a matter of law, that the business judgment rule and other principles of corporate governance will never be a hammer with regard to Homeland security concerns. It just won't work. Next slide. I think that the more realistic approach, the alternative, is to look very carefully in ways to leverage market pressures to enhance security and reliability. This is going to mean starting at the chief executive officer and the director and officer level. It's going to mean a lot more awareness, a lot more public-private discourse over the responsibility that private sector owners and operators have for national defense and homeland security purposes. If you go into some of the board meetings, the questions that you will hear are as follows. I own and operate a nuclear facility. I know right now, before 9/11, that I can defeat 5 commandos. After 9/11, I'll raise that so that I can defeat 10 commandos. 20 commandos, I simply cannot do. That must be the government's responsibility. So even if the government takes on some responsibility for that, maybe through tax relief, maybe through research and development, how do we get between 10 commandos and 20 commandos? This is kind of a coarse example, but it actually reflects the type of conversation that's going on right now in corporate boardrooms. If I spend all my money on security, there's no reason for me to be in business. Another way to move forward is to encourage the auditing sector to take a leadership role. I think that Enron has revealed that some of our leading auditing professional associations have not focused on this issue appropriately. In fact, I would argue they haven't focused on it at all. There are a number of reasons for this, and perhaps during the question and answer session we could raise some of them. But what we need to do is to break out our own velvet hammer and get some of the professional organizations that issue security guidelines, such as GAAP and FASB, to focus more squarely on this particular problem. Finally, I think this is going to mean defining new roles for government where market forces are simply insufficient. Where are the gaps? How do we get from 10 commandos to 20 commandos? Next slide. Go ahead and skip that one. I'd like to draw several conclusions with regard to some of the information that I've raised. First, the problem. How to enhance critical infrastructure assurance. I've argued that our nation lacks a single integrated policy, one that accounts for intelligence, law enforcement, and national defense, one that accounts for business, and one that accounts for response and recovery, human lives as well as property. Many of you have perhaps had to think about what you would do if you knew that another plane was flying into, say, the Pentagon or the White House, and now you had the option of shooting it down. What do you do? One question, how much time did we have as a government to shoot down the plane that went down in Pennsylvania? These are very painful policy options. In the critical infrastructure space, there's a similar question. At what point do you take valuable resources and start focusing on recovery of the stock exchange or recovery of a power grid? The solution lies in honest and open debate on equally valid policy options. We need to take a look very rigorously at research on legal solutions. If the Federal Response Plan and the Stafford Act simply were not developed for this environment, it's time to look at a revised Stafford Act or a whole new series of authorities. I think that in sum, this is about legal thinking steeped in various life experiences and professional disciplines. Thank you.
Judge, Dr. Sullivan, thank you. Thank you for inviting me here today and allowing me to join you. I appreciate the invitation to be part of this panel, but I'm even more grateful for your decision to have this seminar in the first place. If you believe, as I do, that defending the country and its citizens is one of the primary reasons we have a federal government, then the issues surrounding Homeland Security and terrorism must get more of our attention. This topic reminds me a lot about the old joke of the blind man and the elephant. It's so big and so tough that what you see depends upon which part you touch. And you've already heard from Lee on a very important part of critical infrastructure. This is very much the same for Congress. Even 6 months after the tragedy of September 11th, we're still just beginning to define, much less understand, the problem. Before we talk about what's going on in Congress, I think it's helpful to at least frame some of the issues that Congress and the administration have to face. I'm not going to offer solutions to these, but just offer you some of the questions that we're grappling with. First, what is the definition of Homeland Security? Second, is there a clear and compelling threat to our homeland? And what are we doing today? Can we quantify it, and can it be assessed? Next, is there an overarching Homeland Security strategy? What is the appropriate role for the federal government, the Department of Defense, other federal organizations, state and local governments, first responders, and non-government organizations? Do we have the right organizational structure in place? Are there adequate resources being spent on identifying the threat, preventing another Homeland attack, preparing for attack should they occur, and subsequently responding to the aftermath of such an attack? Finally, what is the appropriate role for Congress? There are a lot of hard issues here today, and I'd like to spend some time focusing on some of the initiatives and problems in Congress. And then, if you'll indulge me, I'd like to also spend some time addressing a bipartisan, bicameral piece of legislation that my boss, Congressman Matt Thornberry, and Senator Joe Lieberman are working on to improve the organizational structure within the federal government. I've been asked to share a view from Capitol Hill, and I think it's important to let you in on a little secret. There is no one congressional view on Homeland Security, or any other issue for that matter. There are as many opinions on any given topic as there are members of Congress. With that caveat, I will tell you that everyone thinks Homeland Security is a very important issue. So important that I decided to tally how many pieces of legislation have been introduced since September 11th. The numbers are kind of staggering. 25 pieces of legislation have been passed, 58 are pending with floor action, and 213 have been introduced, all somehow related to the topic of Homeland Security. Now, that does not include the number of speeches, dear colleague letters, GAO investigations, or countless hearings since that time. As a matter of fact, just in the House alone, there were 10 last week. Now, with all that activity, sometimes it's really hard on Capitol Hill to gauge progress. But that's not to say Congress has not taken some forward-leaning steps. Mostly they relate to what we do best, and that's pass out money. So far, Congress has appropriated a $40 billion emergency response fund to wage the war against terrorism, aid the reconstruction efforts in New York and Virginia, compensate victims, and strengthen defenses at home. A total of $10.6 billion was specifically dedicated to Homeland Security, which has allowed the federal government to do several things: increase the number of sky marshals, acquire medicine to treat up to 10 million more people for anthrax or other bacterial infections, distribute $1.1 billion to the states to strengthen their capacity to respond to bioterrorism, deploy the Coast Guard and the National Guard, and acquire equipment for major mail sorting facilities to combat anthrax and other biological weapons. Also, the Emergency Response Fund supported the largest criminal investigation in the history of the United States. In another piece of significant legislation, which I believe we've heard about today, or yesterday, Congress also passed the USA Patriot Act that dealt with 4 broad areas. First, it enhanced law enforcement's ability to conduct electronic surveillance. It It adopted measures to combat money laundering. It enhanced INS's ability to detain or remove suspected terrorists at the borders. And it authorized grants to improve state and local governments' ability to respond. And with all that attention, invariably, more money is yet to come. The House Budget Committee passed, and it's likely Congress will eventually approve a $38 billion piece of money that President Bush is requesting for Homeland Security in 2003. That's up from $11.8 billion in 1999. The Pentagon will secure the largest or lion's share of the fund at about 22%, with the Department of Transportation falling closely behind at about 20%. Also, there's supplemental funding plan for this year that will total $27.1 billion, with at least $5.2 billion specifically geared for Homeland Security. Now, not to put too fine a point on it, but Homeland Security is clearly a growth market. And sometimes it just amazes me that everything up on Capitol Hill is getting that Homeland Security label slapped on it. Everything, including new bridges in West Virginia. Now they're incredibly important resources for our Homeland Security mission. I was reading a study by the Teal Group, and they said the market for Homeland Security products and services will exceed $45 billion a year from 2003 through 2006. And then it could top $50 billion at that point. Of the total, local and state governments are expected to contribute between $7 and $8 billion per year, and federal government money is expected to rise from $37 billion this year to $42 billion in 2006. A Teal Group analyst said, quote, "Our government is making a major effort to counter the threat, but terrorists have hundreds of targets to choose from and a range of weapons. Recent events have shown the need for an overhaul of some government agencies and how they operate." And it's that last statement, the need for an overhaul of some government agencies, I'd like to turn our attention to now. Now, rearranging the boxes in an organizational chart is not fun, it's not sexy, nobody really cares about it, but it really needs to be done. Our national security apparatus has not changed significantly since the National Security Act of 1947, which also was brought about by failures of organization during World War II. I believe the events of September 11th and the government's response bore out the recommendations of several studies and reports in the last couple of years on the world security environment, not the least of which is one that Suzanne participated in, and Lee participated in, the critical infrastructure assurance as well. In January 2001, the Bipartisan Commission on National Security of the 21st Century issued a report that found that the combination of unconventional weapons proliferation with the persistence of international terrorism will end the relative invulnerability of the U.S. homeland to a catastrophic effect. Boy, were they ever right. A direct attack on American citizens on American soil is likely over the next quarter century. The risk is not only death and destruction, but also demoralization that can undermine global U.S. leadership. We've often heard about the dangers associated with nuclear, chemical, or biological weapons being smuggled into this country. But we can also be devastated by computer attacks against our critical infrastructure, or even by livestock and plant diseases being introduced into our food supply. Let me give you just one figure that caught my attention. Every day, $8.8 billion of goods, 1.3 million people, 58,000 shipments, and 340,000 vehicles enter our country. But the Customs Service is only able to inspect 1 to 2% of them. The volume of U.S. trade has doubled since 1995, and some expect it to double again in the next 5 years. And yet, by every account, we're not doing enough to protect our citizens. The Commission on National Security in the 21st Century found that in the face of this threat, our nation has no coherent or integrated government structures. In July 1999, a report by the Commission to assess the organization of the federal government to combat the proliferation of weapons of mass destruction concluded that a cardinal truth of government is that policy without proper organization is effectively no policy at all. If the federal government's policy is to combat the threat posed by the spread of weapons of mass destruction, then the government must be organized to do so. 1 year later, a study by the National Commission on Terrorism echoed this conclusion when it found that this country's seeming inability to develop and implement a clear, comprehensive, and truly integrated national domestic preparedness strategy means that we will still remain fundamentally incapable of responding effectively to a serious terrorist attack. The Commission also found that the complex nature of the current federal organizations and programs makes it very difficult for state and local authorities to obtain federal information, assistance, funding, and support. The General Accounting Office recently questioned whether having terrorism response teams associated with the National Guard and Reserve and with the FBI with FEMA makes sense. Not only may there be duplication, but there may be confusion about who's even responsible for dealing with an incident. Not much of an overstatement, but Homeland Security is a big, complex problem. No one bill, no one branch of government can address all the needs. We clearly need a strategy to reduce our vulnerabilities. We need appropriate funding of the efforts we make, and we need effective organizational structures. I think President Eisenhower put it pretty well that when he said the right system does not guarantee success, but the wrong system guarantees failures. A defective system will suck the leadership into its cracks and fissures, wasting their time as they seek to manage dysfunction rather than making critical decisions. I think it's a good time now to change course a little bit and talk about some specific legislation. Over a year ago, my boss, Congressman Matt Thornberry, introduced a piece of legislation called H.R. 1158 that attempted to deal with part of the organizational deficiencies that created by having literally dozens of agencies with some responsibility for Homeland Defense. This bill doesn't try to fix all of the problems. It doesn't deal with the military's role in Homeland Security, for example. It does not try to legislate a particular strategy, but it does try to force more integration, coordination, and planning so that we can prepare for uncertainty. This bill actually tried to implement one of the recommendations of the Commission on National Security in the 21st century. I think it's important to say a word about that commission. Now, we're all used to commissions after commissions, producing report after report that sit on a shelf somewhere and never come down and just collect dust. I think if we allow this particular report to simply sit on the shelf, history will not be kind to us. This commission was unique in the exceptional background, experience, and I would say gravitas of its members. Their political philosophies ranged from the left to the right, and anytime you could get Newt Gingrich and Andrew Young to agree on anything, it's probably a pretty good thing. But they unanimously agreed on the nature of the threats we face and our lack of adequate preparation. Most amazingly, they all agreed on what we should do. Following their recommendations, H.R. 1158 would essentially do three things. First, it would transform FEMA into a national Homeland Security agency using its existing regional structure. The agency would provide one central focal point and contact point for the other federal agencies or from state and local entities. Its director would answer to the President, and it would give priority to operational planning and coordination. Second, H.R. 1158 would bring the Coast Guard Customs Service and Border Patrol under the umbrella of the Homeland Security Agency as distinct entities. Each of these agencies are in departments where their mission is very different from the core mission of that department. Each of them play an integral role in protecting our borders, yet there is not the coordination we need. As part of this new agency, the bill would also consolidate a variety of programs to protect critical information and infrastructure that are now scattered in a variety of places of the federal government. As we try to do a better job in preventing and preparing for homeland attacks, which are sure to come, the lines between foreign and domestic terrorism, between law enforcement and military functions will become fuzzier and fuzzier. The constitutional and civil libertarian concerns about what all this will lead are real. Some of you may remember an outcry when a military serviceman shot an unarmed civilian along the Texas border a few years ago. This bill tries to remain sensitive to those concerns by using civilian agencies while also making sure we are more effective in fulfilling that first function of the federal government to provide for the common defense. In the intervening 6 months, the administration has made some progress in naming Governor Ridge as the Director of Homeland Security in the White House by creating the Transportation Security Agency within the Department of Transportation. But organizational reform, however, has not gone far enough. According to press reports, an interview As a matter of fact, I know of no one who stands up to defend the current diffuse arrangement of Homeland Security-related agencies. No one can defend it. The only issue is, what do we do about it? Now, reportedly, Governor Ridge has submitted a proposal to the President to merge the Customs Service and Border Patrol, and then keep the combined agency within the Department of Justice. It seems to me that such an arrangement may be somewhat better than what we have now, but it falls far short of what we should and could do. In fact, I worry that the administration and Congress may take the path of less, if not least, resistance, splitting the INS in half, bringing customs over to justice to be put in with the Border Patrol, and pretending we've solved the problems. I think now is the time to get it right, and we ought to do our best to do so. Since Congressman Thornberry introduced the original Homeland Security Bill in March 2001, he's come to believe that we can and should do more. Right now, we are working with Senator Lieberman and others to try to build on that first bill that he introduced. That includes, in the first part, adding the Department of Agriculture border inspectors and the INS inspectors within that border security section of the new department. It would also add a robust R&D organization to act as a clearinghouse and integrator for private industry and within the federal government for Homeland Security technologies. Now, using the drug czar model, the new bill will also add a Senate-confirmed position within the Executive Office of the President to develop a government-wide strategy to have coordination and accountability on the wider sphere. Then, even if a particular issue or question does not fall into the new Department of Homeland Security, Congress will have somebody they can ask about it. A czar or White House coordinator cannot take the place of a cabinet officer who has a clear chain of command and direct budget authority, but it can provide an added benefit in overall strategy and budgeting. The new bill, as a third section, will also mandate completion of a national strategy and submission of annual budgets for Homeland Security, along with an independent review mechanism. Finally, Congress should remind itself of the need to look in a mirror at its own organizational structure, in which at least 15 committees have some responsibility for Homeland Security. Some sort of select committee with appropriate staff and expertise would help us focus on these issues. Still, with all the turmoil in the world today, organizational reform does not seem to be a high priority issue. And the temptation to let it slip, to not take on turf battles in the bureaucracy and in Congress, to just pour more money, a lot of money, into existing fragmented agencies and to express our shock when something bad happens may occur. We cannot fall into that trap. Even if we organize ourselves perfectly, we cannot guarantee that more Americans will not be victims of terrorism. But if we make half-hearted attempts, then we bear part of the responsibility for failing to do all we can do to protect our homeland and the people who inhabit it. Thanks very much. Appreciate it.
Make sure that we have plenty of time for discussion, because like the previous two speakers on this panel, I have more questions than answers for you. I'm going to talk a bit about how the changes since September 11th have impacted the legal framework that we've established for law enforcement and intelligence. Particularly in the area of law enforcement with respect to the mission of the FBI, my sense is that we are witnessing a very profound and fundamental shift, the implications of which we will still be sorting out years from now. We are only now beginning to see the outlines of those implications. The FBI has been asked to take on a new role. Its mission now, its new director, Bob Mueller, and Attorney General John Ashcroft are to be believed, its new role is now not catching criminals, investigating crimes, and prosecuting criminals, but preventing acts of terrorism. Their role in Homeland Security, defending the homeland, has become very central. And as I said before, I think the implications of that are profound. mean, the FBI has been inching toward this greater emphasis on prevention, certainly at least since the first World Trade Center bombing in 1993, when it became very evident to all of us, and certainly those of us in the realm of national security, that this battle was moving to the homeland. We had been attacked by international terrorist foreign entities on our home soil. Their objective in that attack, of course, was to topple one building into the other. They hoped to kill as many as possible, if not all, of the 50 to 70,000 people that regularly work and visit those buildings every day. So there was no question at that time about what the objective of these terrorists had become and was. Shortly after that bombing, we uncovered the plots for further attacks on landmarks and tunnels and bridges in New York City. The plot to bring down 11 U.S. airliners on international flights. I mean, we had lots of warning and indications of the seriousness with which the terrorists were now moving to take as many American lives as possible. And as a result of that, the Bureau did begin to shift an emphasis toward prevention. And in fact, the previous FBI director, Louis Freeh, used to talk about how prevention was important, and if in the course of investigating crimes, investigating and trying to bring terrorists to prosecution, they uncovered information that would be important to share to try to prevent an act of terrorism, even if it meant that it would frustrate the prosecution. He had made the decision that obviously that was the most important thing, preventing the next act of terrorism. That's, frankly, I think about as far as the Bureau got in terms of its prevention mission before September 11, for the most part. And what we've seen now is something much more dramatic. Now it's not as a consequence of investigating prior criminal acts. It is go out and find people who are thinking of doing us harm. Think about that in contrast to the way we normally have looked at prevention within this country. For example, the FBI's role in bank robberies. If you wanted to prevent a bank robbery, you would put locks on the door, you hire security guards, you put up surveillance cameras at the bank so that if the robbery happens, you can go and capture those who perpetrated the crime. You didn't spend a lot of time trying to figure out who out there might be interested in robbing this bank. And yet that's exactly what we've now asked the Bureau to do. The CIA has long had this kind of a mission. Go out and find out, figure out the plans of intentions of anybody who threatens the national security interests of the United States. And they have broad authorities to do that, and we've limited them to doing that overseas. Because to do it within this country, the kinds of things that they do, if they did it against U.S. citizens in this country, would raise very significant constitutional issues. Asking the FBI to do that in this country is going to raise many of those same issues. What the CIA has done, and again, we can see some of the creeping over from the CIA's mission into the FBI. What the CIA has come to with respect to the counterterrorism efforts, particularly pre-September 11, was disruption. Because they found that penetrating the terrorist target was so difficult, and getting tactical information. Jim Pavitt last night, the director of operations, talked a little bit about this. Getting tactical information that would say an attack is being planned for this day against this target at this time by these individuals proved to be incredibly difficult, virtually impossible in most situations. And so but they were able to oftentimes identify people that they thought might be engaged in this kind of activity, and so they would periodically shake them up a little bit by either arresting a couple of them for other purposes or changing routines, things that would sort of make the terrorists think that we were onto them and that we did have some tactical intelligence, and that then they would, shut down that plan and begin planning something else. Well, we see the Bureau now talking a great deal about disruption. And we see that they immediately went and detained 1,200 individuals either for immigration violations or oftentimes as material witnesses. And one of the justifications of that was disruption. Again, I think we have to look at that context versus the context in which CIA operates, and try to help the Bureau as it works its way through the mission that we've given it to figure out what kinds of authorities that we want the Bureau to have and how we want it to operate in carrying out that mission. I think one of the reasons that we haven't heard more discussion and debate about this issue is the rhetoric of the war on terrorism spilling over into the domestic context. During war, we have come to expect a certain amount of collateral damage. We try very hard to minimize it. We don't like it, but I think all of us, most of us, recognize that that is an inevitable consequence of a military conflict of a war, that there will be some collateral damage, that there will be some mistakes made. And I think, to some extent, our thinking has been influenced by this war rhetoric such that we are a little more accepting, at least in the months immediately following September 11th, of some collateral damage, of some mistakes being made, in a way that we normally would not accept in the law enforcement context. We don't generally accept the concept of collateral damage in the law enforcement context. So I think the rhetoric has influenced the public's discussion and debate on this topic, but I think the public discussion and debate has got to get very much energized, and you all being here and are talking about these subjects is extremely important. We have a responsibility here. In part because we are asking these folks, and again, particularly at the FBI, to move into uncharted territory and take these risks, and mistakes will be made. And the tendency, certainly on the Hill, Congress, is to then hang people out to dry, call them down, and find scapegoats and cast blame. And yet we are asking them to undertake this mission, and we are not giving them, I don't think, the appropriate guidance for how we want them to undertake this mission. And I think mistakes will be made. And it's important that we work this out so that when we can then stand behind these individuals who we've asked to take these risks. In the intelligence context, I look at the shrugging of shoulders when my commission, the National Commission on Terrorism, for which I was executive director, recommended changes in the way that we approve recruitment of terrorists. We had set up, the CIA had set up in the mid-90s a rigorous process for reviewing those sorts of recruitments, and there were a lot of people who were very frustrated and thought that created risk aversion, and that was what was holding back our recruitment of terrorists. And indeed, I think it did have a chilling effect. And so our commission recommended that those guidelines be rescinded with respect to recruitment of counter-terrorist assets, and that the normal vetting process for assets be employed. And we thought that was a fairly significant recommendation. It was met with a shrugging of shoulders, as if to say, of course we should be recruiting terrorists. Well, I think it's true that of course we should be recruiting terrorists, but as we now direct the CIA to be much more aggressive in recruiting terrorists, we have to recognize that there are significant risks attendant upon those kinds of recruitments. And not just risks to the lives of those who attempt those recruitments, but the risk that the next terrorist hijacker we will find after the fact was on the CIA payroll. Because you cannot totally guarantee that you can control these individuals. And what's Congress's reaction going to be? Having shrugged its shoulders and said, go recruit terrorists. Is Congress going to support the agency if it's found that they took all reasonable precautions and did everything that they could to try to control the running of this operative? It's a legitimate question. And the Bureau faces now the same sort of dilemma. Last time we asked the Bureau to undertake this kind of a mission was in the late 60s and early 70s. And we all will recall some of the results of that effort. The question is, can we move forward and put in place an effective legal framework that will enhance our ability to prevent terrorist attacks in the future without repeating the mistakes of the past? And my own sense is that it's not adequate simply to say, no, we don't want the FBI to do that, or no, we're not going to give the FBI any additional authority. My sense is that we've got to roll up our sleeves figure out what kind of authority the Bureau needs to have in order to protect us against what is a very real threat. Think now about whether there are safeguards we can put in place that will minimize the potential downstream damage from granting those authorities. Can we, for example, stockpile legal authorities that could be used in an emergency? For example, to prevent imminent loss of life. Can we imagine now the pressures that will be placed upon decision makers to take certain steps? And as I've talked to decision makers, current and former, about these issues, there's a general consensus that decision makers will take the steps that need to be taken in a crisis situation, and if they have to, they'll worry about the legal niceties later. And it may be that that's the best we can do, but I have a sense that we can do better than that. That we can anticipate the pressures they will be under, the decisions that they will feel they have to take in order to protect American lives, and begin to develop those authorities now with appropriate safeguards as best we can, with an effective trigger on and off switch. Set forth the circumstances under which these extraordinary authorities could be employed and when they will expire. For example, in the Foreign Intelligence Surveillance Act, which allows electronic surveillance of U.S. persons within the United States if they are acting as agents of foreign powers or surveillance of foreign powers here in the U.S. FISA, Foreign Intelligence Surveillance Act, sets forth procedures for emergency situations that allow an expedited approval of an application by the Attorney General without having to take it first in front of a judge, and then subsequently you can begin the surveillance, and then subsequently you go and get it ratified by a judge at the FISA court. But there's no emergency standards in FISA. The standard is supposed to be the same. The reality is that in a crisis, and we saw this at the run-up to the millennium, judges are much more likely, and the Attorney General is much more likely, to approve an application and it will approve applications that it might not approve in a non-crisis situation. And in fact, the Bureau told us this at the National Commission on Terrorism. In ordinary circumstances, judges require A, B, C, D, E, F, and G to be on the application. They want all of this facts to prove that you have probable cause to believe that this is an agent of a foreign power. In the run-up to the millennium, A, B, C, and maybe D was adequate. And again, maybe that's the way we want it to work. That's why we have these things go in front of judges. Judges can take account of what the current situation is and the dynamic and make sensible judgments. My concern is if we haven't given the judges any guidance, if they're not applying the standard, sort of open season, we've given them no guidance for where to go in a crisis situation. And again, my sense is that we can probably do better than that. But it requires some very careful thinking, and it requires us to have some trust in our government. We're going to give them some extraordinary authorities and say you can only use it under these circumstances, that in fact it will only be used under those circumstances, and they'll stop using it when those circumstances cease. I'm going to stop there so that we have time to talk about these issues, but I think it's incredibly important, as I said before, that these authorities, these decisions, come about as a result of a democratic process in which the public has vigorously participated in the discussion and the debate. I know that these issues are being looked at right now. One of the issues, for example, that I was going to mention is the use of national technical means, imagery, satellite imagery, within the United States. Currently, there is no authority for using that within the United States if you're focused, if it could be viewed as collection against U.S. persons, because it's a foreign intelligence asset. Now, again, I've heard from senior officials who have said if using satellite imagery to collect against U.S. persons is essential in a situation to protect American lives, they're going to do it. They're likely to do it. Rehnquist concludes that it's not silent, but it does speak with a different voice. I think, again, if you look at the dissent of Justice Jackson Korematsu, that's very good discussion about why you might not always want these sorts of issues during a crisis to be resolved in a court. Executive order is maybe an effective way to go, allows for dynamic, more flexibility. Congress certainly provides the most democratic scrub of these kinds of authorities, but tends to be cumbersome. And Congress also tends to be deferential during a time of crisis, particularly when they have the Attorney General of the United States saying that they will be responsible if a terrorist attack occurs before they adopt these authorities. So I will close with, again, another plea for public discussion and debate with a quote from Justice Stewart in a concurring opinion in the New York Times versus United States, in which he talks about this. In the absence of governmental checks and balances present in other areas of our national life, the only effective restraint upon executive policy and power in the area of national defense and international affairs may lie in an enlightened citizenry, in an informed and critical public opinion, which alone can here protect the values of democratic government.
We had in place something called Plan D, which was a program that would be activated if the worst happened, or perhaps was about to happen. One of the elements of Plan D was the preparation of a series of documents that the president would carry around with him at all times, I guess along, maybe in the same briefcase for the football. And one of those documents that would be pulled out and perhaps signed in a great emergency was one called Presidential Emergency Action Directive Number 21. And that included a direction to declare martial law throughout the United States. My question is this. You indicated earlier in your remarks, Suzanne, that we need to think about the desirability of some standby rules. Should we have standby rules like this? Should we have documents and programs in place to deal with great emergencies that events like the attacks on September 11th presented? And to the extent that we have such plans or programs, standby plans in place, should the American people know about their existence, and to what extent, if at all, should they be informed about the content of those programs?
Well, of course, we have all kinds of emergency authorities in existing law, all kinds of authorities that kick in upon the declaration of a national emergency. We just don't have them really in the context of law enforcement and intelligence. As I indicated, my sense is that that's something we ought to seriously consider. If only to forestall, for example, a general declaration of martial law. I mean, we have no tradition in this country, thank goodness, of suspending the Constitution because of an emergency situation. And in fact, there was a reference earlier today on the first panel to the context in which that Constitution was drafted. Talk about an insecure situation with a new fledgling country that had just emerged from conflict. I firmly believe that they crafted that document in a way that will allow us to protect our national security and preserve the existence of this country within the confines of that document. But the pressures will be tremendous. And it is my sense, as I said, that thinking through those pressures and trying to anticipate them and bind them as best we can in advance is a much smarter way to go. In terms of should the public be aware of them, it's hard for me to imagine, while I can certainly understand that there are all kinds of plans that would need to remain confidential in terms of continuity of government, for example, so that they cannot be defeated me to conceive of a situation in which legal authorities that we would grant to our government in a time of a crisis would need to be kept secret. In fact, quite the contrary, it seems to me that what I'm arguing here is that those very much need to have what I call a democratic scrub, that they really need to be the subject of vigorous discussion and debate, and I think we ought to be aware of what decisions are made in that context.
There's a question over here.
Thanks. I'd like to start over with the Heritage Foundation. My question is also largely directed at Ms. Spaulding. You discussed one of the cultural changes that needs to take place within federal law enforcement, from that of merely prosecuting crimes to prevention. That's absolutely necessary, right? And we probably do need to look into the issue of how we're going to do it more. But there's another cultural change that needs to occur, and that's sharing information better. Currently, the FBI doesn't share information not only enough with the federal government, but with the private sector, state and local law enforcement, as well as even with its federal offices. Too much of its information stays in its field offices. We've seen this with September 11th. A number of agencies had information on some of these guys who were responsible for the attacks, but nobody was able to get the broad picture precisely because nobody shared information. And the FBI is frequently cited as the primary obstacle in that area. So what steps do you think could be taken to change that culture? And I'd, of course, be interested in hearing what the other panelists have to say on that issue as well.
Yeah, and Kim can address, there are a number of efforts on the Hill, particularly now with respect to sharing with state and local. The USA Patriot Act, of course, attempted to address that through a mandate, mandating that the law enforcement community share foreign intelligence information with the foreign intelligence community, with the national security community. Obviously, it's much more complicated than a mere mandate. It did also address some of the legal obstacles to sharing information, which have traditionally been thrown up. But as we learned this week in even more gory detail from Judge Webster's report on the Hansen case, information management at the Bureau, as we've known for a long time now, is a disaster. It is a major mess. And that needs to be fixed first, and there's not a real good short-term fix for that. That's going to take time. In part because even when you put in all of the technology and the new procedures, the first step is going to be identifying what information they have now and beginning to corral the information that they've accumulated over all these many years. Decentralization is a critical issue in the field offices. It's also information that traditionally has not been put down in files. One of the issues that came to our attention on the Terrorism Commission was that as FBI was involved increasingly in investigating terrorist attacks overseas, they would go overseas and interview folks and gather all kinds of information. The only information that ever made it into the files was that which was directly related to the prosecution, to the criminal investigation. And they had gathered significant amounts of information that an intelligence analyst would have loved to have gotten their hands on. It wasn't just a case of an unwillingness to share it, it's that there was no mechanism within the Bureau for even keeping that information, let alone sharing it. So that's a big issue. But there too, as they begin to do that, we need to make sure that we do it in a thoughtful way with the appropriate safeguards and monitoring of what information has been shared and what should be shared and what needs to be classified and what doesn't. One of the things that we saw in the immediate aftermath of September 11th is that a lot of those barriers broke down and they started sharing information very readily for efficiency's sake, and things that probably shouldn't have gotten into certain people's hands, were widely disseminated, and there was few records kept of what was and wasn't. And so there too, we need to be more sensible about it.
Judge Everett?
Robinson Everett of Lens. I have a question for Suzanne and sort of a follow-up to a couple of things. I know we've adopted some new legislation to deal with the problems of 9/11, the Patriot Act, and so forth. Is there, however, a need for a review of federal criminal legislation with a view to taking into account and creating inchoate offenses, things that are crimes at an earlier stage, so that something could be done at that time in terms of either investigation, getting warrants, and arresting persons? Then secondly, if the role of the FBI is changed, so that concerned with prevention and will not be as involved in enforcement. Has there been an effort to alert the states to this situation and to work with groups like the Center for State Courts or the National Conference of Commissioners on Uniform Laws to develop state laws that will help fill the void somewhat? And if not, do you think that sort of thing would be desirable?
On your last point, absolutely. And I'm not aware that there's been on the federal level a real recognition of the role of the state and local law enforcement, both in terms of assisting in the prevention mission, but as you rightly point out, picking up some of the slack that will be created as resources are diverted from traditional law enforcement. But I know that at the state and local level, they are aware of this, and they are beginning to talk about this more and raise these issues. So I'm hopeful that that discussion will begin. It may have to, as I say, begin from the bottom up rather than top down. But it is a very real issue, and the states are very much aware of it. In terms of, do we need to relook at our criminal law from a prevention standpoint? That's certainly one of the issues that some folks have been looking at, that the conspiracy statutes, which is what they mostly rely upon now, it's the best, sort of their best hook for when you have not yet had a crime committed. In many of these situations, it's not adequate to give them the legal authority that they need to proceed. And of course, part of why the FBI's ability to even compile publicly available information about an individual or an organization is dependent upon some level of showing with respect to potential criminal activity. And because, again, that's been their mission, law enforcement, enforcing criminal laws. And so it's a very real issue. If there is no criminal predicate yet in place, the FBI is extremely limited in terms of what it can do. So whether the answer there is to make it easier for them to do some preliminary investigation activities, or to create a legal hook that would still tie it into the criminal realm, I'm not sure what the answer is there. As I said, I've got more questions than answers, but those are certainly things that people are looking at.
Kim, let me ask a question, if I may. The proposed legislation by Mr. Thornberry and Senator LegalNet, would it envision someone such as Governor Ridge heading up this agency and taking over the day-to-day operation of these various sub-agencies?
There's actually two parts to the answer. One, for the border piece of it and for the response piece of it, you would set up a federal department that has total accountability, has the operational mission, has the budget and the wherewithal to go out and put feet on the ground, make sure there's commonality among radios and people, and to foster this culture that we need for border protection and for recovery. So you set that aside, that's piece one. Piece two would be at the executive office to have a drug czar-like person, Governor Ridge, if you will, to come up with the nation's strategy for combating terrorism and homeland defense, to be the budget authority that takes all the input from the rest of the federal departments, oversee it, integrate it, tell the White House and tell Congress that this budget is certified or not certified to meet the national objectives. So it's not just one answer, but it's a two-part answer.
I can see how that would be a tremendous hurdle.
The rice bowls are like nothing you ever imagined.
Any other questions from the audience? I have just one more lead for you. What you learned is the actual threat on our infrastructure? Is it more domestic threat, hackers and so forth, or is it a foreign threat?
If you'll permit me, I would say that if you ask the operational folks who own and operate the critical infrastructure, they will very rarely focus on the threat. And so with regard to the gentleman's question concerning the sharing of threat information, what's more important is to partner on areas of common vulnerability and then to share that information back and forth with the federal government, and then only then focus on threat.
Professor Dyke?
I just have one quick question for Lee Zeichner. You indicated that so far we lack a single integrated policy for infrastructure protection, and you might have said, and would say in addition, single integrated policy for consequence management as well. My question is, why do we lack such a policy, and how can we get one?
Professor Dyke is an excellent question. I think in part things have happened very quickly. You couldn't bring down the financial services sector within an hour 10 years ago. But now, because of our incredible and unpredictable reliance on information technology, these things can happen very quickly. Quick anecdote, after the towers fell, Fannie Mae learned very quickly that it was relying on a single flow of information services, which were the real-time supply of bond calculation rates from a firm called Cantor Fitzgerald. Never knew that before. Without that supply of calculation rates, it was very hard to perform the financial services that Fannie Mae provides. And then there's a metric with regard to those particular services and how the housing market begins to implode. So I think that in general we've seen information technology become part of our core business practices, not email, not advertising on websites, but core business services in a way that we haven't really prepared for. I think in terms of the next step, it really is an education awareness issue in part, and then also sitting down with folks like Representative Thornberry to work out policy solutions that include folks like you and others in a general debate. I think that until we have that kind of national discussion that includes an education awareness component and then a policy debate in Congress, not from the executive branch, I think it's going to be very hard to come up with an appropriate policy.
I might just add to that too, that and Kim probably could add as well, that I think one of the real challenges that we still haven't grappled with respect to critical infrastructure protection is the need for a true partnership between the private sector and the government, and not just give us information, each side asking the other side to share information, but in fact an integrated security planning process where we recognize, the government recognize the role that the private sector can play in security planning and in responding to attacks, the security resources that they bring to bear, and integrate that with the federal capabilities, planning and response capabilities in a way that we're still not there.
Just an additional comment, technology is moving far greater than the human mind can process, particularly the minds of staff of Congress. These are extremely complicated issues, and until we can get folks like Lee and Suzanne to come up and put in very clear terms what the issues are, what the implications are, and then what some of the solutions are, it's going to be very difficult for Congress to take action on these very technical, complex issues when they're much more concerned, frankly, with the next election, with Social Security reform, with Medicare reform, with passing the budget and the appropriations bills. So I think it's going to be longer if you want congressional action than any of us would like to see. And in part, we're going to rely and take our lead from the administration on some of these issues.
Got time for one more question?
Mike Scarlogan, just a follow-up to the same line of discussion we've just been having with coming back to Lee's point of the private sector sharing vulnerability and or intrusion information with the government. As you know, undoubtedly, there's a number of obstacles in the way to that. Legitimate concerns that the private sector has, the ability of this information to get out that may require limited FOIA exemptions, as well as just the issue of general security investment by the private sector. Regulation quite probably isn't the answer. Business moves much quicker than Congress does, no offense, Kim, as you just pointed out. By the time you buy a computer, 6 months later, it's out of date. The regulations will be probably 2 years behind. We need to look at using the free market and incentivizing some of this, setting certain standards that we can then point to who's doing a good job, who's doing a bad job, or even just who's doing a good job. But trying, as you were all pointing out, making the private sector an actual partner. Just would like to hear your comments on what really, in addition to maybe the FOIA exemptions, which I talked about a lot, what you think some areas can be done to incentivize it and to take into account the concerns of private sector so they will be more willing to share information.
I don't know. I'm very cynical, to be frank with you. I'm very, very cynical. I'm cynical because there's been a wholesale lack of sophistication, not only within government, but also within industry. The level of awareness, even where business models and businesses are on the line. I mean, look at Enron. If you took the Enron situation, you could analogize that back into critical infrastructure. And I'll close with this. The National Association of Corporate Directors and the Institute for Internal Auditors, two very respected organizations, just came out with a post-Enron poll, and they asked directors and officers and CEOs to rate those issues which were most important. And coming in last place, just behind CEO succession, was risk controls. Risk controls really means security and reliability. The Institute for Internal Auditors had asked how many of you have enterprise-wide risk assessment plans, not looking just at one company, but across the entire company. 32% had. A full 20% had no clue. So, we've got a ways to go.
Thank you very, very much. Please join me in thanking. I would just like to close with one observation that struck me when I was preparing for this Homeland Defense. You know, we could evolve into a Homeland Defense such as maybe the former Soviet Union had in East Germany or Castro has in Cuba and have, pretty tight security. Or we could try to meld it in with our values of civil liberties. And I think that's the challenge, is to retain those. And you certainly pointed out some of the problems in that regard. Thank you very much, Scott. Turn it back over to you.
Thank you, Judge. Some of you will be joining us for lunch with Leon Firth, and that will take place in about 15 minutes. Again, to the ballroom, to your left, my right. I do want to, though, make a few concluding remarks, particularly for those of you who will not be joining us for lunch. First of all, we're delighted that you were able to join us. We hope that this conference has not only been professionally rewarding to you, but personally enjoyable. We've tried to do that. In that regard, as I mentioned at the very beginning of the conference, we have in your folders an evaluation sheet. We do solicit your comments. We want to make these conferences better each year, more appropriate to what's going on in the world, and anything that you can tell us to help us do that, we earnestly desire to know that. Lastly, I would tell you that the co-sponsors that joined us in putting on this conference, their names are listed in your program. I would also want to acknowledge, as we do on the backside of your program, that we had some grateful assistance from not only the Vice Provost for International Affairs and Development, but also Warren and Faye Wickersham, and we want to publicly acknowledge them and their help in putting on this conference. And lastly, but most importantly, I will tell you that this conference started about 5.5 months ago. It takes that long to bring something like this together. And the two people standing in the back of the room have worked tirelessly to do all that. I don't have any idea about all the administrative details that Heather has in that book or series of books back there, but she started to put it together in December. So would you join me in thanking them for a splendid